Hey Bay Area, welcome to another episode of Ask Me Anything. I'm Yasha Saba and I'm here to answer your estate planning and asset protection questions. First question, how do I know if my recently deceased father left me money or property? Sorry to hear about your dad. Neither his wife nor stepdaughter won't discuss it. I'm 22, an only child, and was raised by my dad alone. I never knew my biological mother. Okay. So you were raised by your dad, you have a stepmom and a stepsister. First question, did your dad own anything as a joint tenant, or did he have any beneficiary designations? Were you listed as a beneficiary on his retirement plan, his life insurance? Was his home, is it owned by him and your stepmom or just him alone? Usually when no one's saying anything and you don't know anything regarding your dad's estate plan, the best and first thing you can do is file a probate petition. This means you are going to court in the county where your dad passed away, and you are filing a petition to become the administrator of his estate. By doing this, you give notice to all those involved in your dad's life. That means your dad's wife, your stepmom, you need to give notice to her. Any of your dad's other children. So the stepdaughter, is that his biological child, or was that just a daughter from his new wife? Did he adopt this stepdaughter? If he adopted her, treat her like she's your sister, because under the law, she inherits just as if she is another blood relative. But if he did not adopt her, then she's not included because she's not his heir. She's not his daughter. She's just a stepdaughter, right? Who cares about that? But for you, by doing this, when you file that petition for probate and you say dad doesn't have a will, everything comes to me, he has a wife. Remember, some things do go to his wife under community property laws, but not everything. Then if there is a will, if there is a trust, if there's anything, whoever has it is going to come forward and bring it saying, oh, no, you can't be the administrator because there's a will, and here's what it says. And that is how you can get notice of what that is. Either way, if there's a will, it has to go through the same process. And if there's a trust, the best way you can find out if dad owned a trust is the property that he lived in. Did he own it? Who owns it? If it's him, there you go. So that, I think, is your first step, is just opening up a probate. And that is how you get information fast, because now the court process has started. And if nobody steps forward, then you become in control. And when you're in control, you can then have a say on what happens next. But right now, you're not in control and no one's talking to you. So the best approach is open up that probate, in my opinion. Next question. I have been married for 30 years to my husband. I found a will he rewrote about a year ago that has him giving our home to his grown 4 kids. Wow. Unless I can buy them out. Our home is in both of our names on the title. Can he do that if I don't agree? Wow, this actually works really well towards that first question. So now your husband has a will and he's saying that his share of the home goes to his 4 kids and you've got to buy him out. Well, first thing you want to do is look at the deed of the home. So when you and your husband created the deed for the home, are you joint owners or are you joint owners as community property? If you're joint tenants on the home, he cannot have a say via will. His will doesn't matter, because in a joint tenancy, when there's joint owners, when one joint owner dies, their interest goes to the other joint owner automatically. So to protect yourself, go and file an affidavit of death of joint tenant. So that way you make a record showing that your husband died and his interest now belongs to you. When you have joint tenancy, the will does not matter, because the will doesn't control joint tenancy or beneficiary designations. Those two come first. Joint ownership and beneficiary designations come first over the will. Anything else is what the will catches. So joint ownership, the joint owners get everything. If you guys had joint bank accounts, you now own the bank accounts. They're not his interest. And then any beneficiary designations, if you were listed on the life insurance, the retirement accounts, you get those. And then the will takes over control after that. So even though his will says it goes to the sons, the problem is his will doesn't control joint ownership. So if you are a joint tenant on the property, that property is yours regardless of what the will says. And when you go to put the will into probate, the real estate's not going into probate because you own it. Your husband no longer owns it because you were the joint tenant. And all you have to do is go file that affidavit of death, all right? So I think you're gonna be protected there, unless the home was not owned as joint ownership, but as tenants in common or some other mechanism or tool used. So you wanna kind of verify title of the home. Feel free to reach out to me at info@skyunlimited.law. or send me a message on Facebook and we can look deeper into that for you. Next question. My mother and father passed away with no will. How do we get the deed to the house in our name? Do we have to do 2 separate probate cases to switch from joint to just dad, then one of us, or can it be done in one case? Okay, you do not need 2 probates when your mom and dad passed away. The question is, who passed away first? It sounds like your mom passed away first while your dad was still alive. So what you can do is this. You can file, just like what I was saying on that second question. The questions really work together today. You guys are kind of collaborating. You do an affidavit of death of joint owner for mom, and you record that with the recorder's office, giving dad full title. So when your dad was alive, mom died first, the joint ownership automatically passed to him. All you need is a death certificate, okay? And you can file that affidavit on behalf of your dad. And then with your dad, you need to take the property through probate. So you need to open up a probate for your dad in order to take his interest. You can't just say, dad died, give me the property now. No, there's an actual procedure that you have to go through, and it's called probate. Right once you do that affidavit of death and just record that and record the date of your mom's death, giving the death certificate to the county recorder's office where the property is located, then that will clean up title to show your dad is the sole owner of the property since he's the survivor. And then you can go into probate to transfer his interest, his full interest on the home, over to you as the kids. And with no will, then you're following California law of intestacy, which means the heirs, your dad's heirs are who inherit. So children, if your dad has children, they are the ones who will inherit the property equally, and then you can handle it from there. One last thing is if you, since you're saying we, I'm assuming that you have siblings, ask your siblings if you guys all want to own the property equally. This needs to be a decision made during probate while the property still remains in your dad's estate, because if one of your siblings does not want to own their share of the property and you guys end up selling each other's interest over to each other after your dad's probate closes, meaning your dad, let's say it's you and your brother, and you go through probate, you get the real estate in your name. When your dad's probate closes, now you and your brother are 50-50 owners. If your brother says, just give me the cash. I don't want the property interest. I don't want to deal with it. I don't care about renters. I know you've got this whole thing where you want to grow it. Great. Just buy me out. There's going to be a reassessment on the property taxes. Now, instead of that happening, if you guys have that conversation before the probate closes, before you inherit the property, you can get a bank involved to give a loan to the estate, and the estate uses that money to buy out your brother. So your brother will get cash, assuming you have a brother. Sorry if you have a sister, just make her a brother for now. Your brother will get cash, and then you will get the real estate in full with that loan converting to a mortgage, and there won't be a reassessment. California law allows this to happen. But what most people don't realize is this conversation has to happen before the real estate is transferred to your names. Because the moment it's transferred to your names, it's out of the estate and it becomes a reassessment between siblings. So this is how you protect yourself. Free advice for the day. All right, that's our questions for today. I hope you are all doing well. Once again, if you ever have questions related to estate planning, asset protection, business planning, business succession planning, feel free to reach out. We'll be happy to help, or send them to info@skyunlimited.law and we will answer them here for free. All right, everybody, take care.